Hey, I'm William Farrell from Fed Employees Fights EEO Abuses. Hey, I'm just reviewing some of my claims. This is my reconsideration request. I posted some prior videos explaining the reconsideration request. I wouldn't say it's the third stage in the process, but it's a possible third stage, being that we are, are not entitled to a reconsideration. But it can happen after your initial ruling, which I endured, then my appeal, which I endured, and then you make a reconsideration based on some specific, very specific terms. I'd like to read to you my claim number 15 so you can kind of get a feel as to how to structure your reconsideration request, and you can also get some insight to the integrity and veracity of the EEO process. So if you let me begin, my claim, item E, is for claim 13. And I'm reading out loud, so my eyes won't make contact as much with the camera, but I'll be doing some reading. The AJ's decision involved a clearly erroneous interpretation of material fact, or 29 CFR 1614.405A, C Universal Cam versus National Labor Board, and Celotex versus Catrix, and Oliver versus Digital Equipment Corps. When, in the March 2nd, 2022 appeal decision, the AJ noted that the complainant's request for a new supervisor, claim 15, was denied after management had conducted an administrative management inquiry and fact-finding investigation, which did not substantiate complainant's allegations. So that's the ruling that the AJ laid down. That's the reason why she made her conclusion. First thing you may have noticed is the entry sentence in this claim. There's only two very specific reasons that we can even have an option to try to make a appeal for reconsideration. One, you would have to prove that the AJ's decision involved a clearly erroneous interpretation of material fact or law. So that's why I wouldn't specify certain cases in which those laws were applicable. I kind of messed up right there. I'm seeing all the other ones I put the principles cited in, right? So I need to do some more specificity right there, and I'll explain to you why in a minute as I go through. The next part of that sentence I explained to you, I repeated the judge's ruling. That plays a critical part. Hang with me. I go on to state here, again, there is no substantial evidence and genuine facts in the record to support or corroborate that the management conducted administrative review, inquiry, and fact-finding investigation ever occurred or was completed. And if so, it was never made part of ROI investigation nor record. That talks directly to the first part of my appeal. She made a clearly erroneous interpretation of material fact. There are no facts on the record to support that. How can she interpret a non-fact? The agency and the record failed, I go on, the agency and the record failed to cite or specify any data or details on the purported administrative management inquiry and fact-finding investigation, such as an investigation ID number, dates of the purported investigation was conducted, investigation summary, investigation details, methodology, authorities, nor did it have the investigator's name or ID number or information to be deposed or any testimony. Neither the AJ nor the complainant was ever allowed to see, read, observe, review, verify, oppose, contest, comment, or otherwise allowed the chance to engage in discovery on the purported management conducted administrative management inquiry and fact-finding investigation before responding if necessary. According to the Supreme Court, Rule 56 itself precludes summary judgment where the opposing where the party opposing summary judgment has not had opportunity to discover information that is essential to his opposition. And that's cited in Anderson, a court case, Anderson, blah, blah, blah. So here, Rule 56 says that, hey, I'm entitled to be able to perform discovery on anything that had impact on the ruling. There's no investigation there. I didn't get my discovery. So there's another thing that the AJ done wrong, or erroneous interpretation of law. All right, let me keep going. The alleged management conducted administrative management inquiry and fact-finding investigation was not attached nor included as an artifact or lawful submission in the EEO process or record. As such, the Commission ruled improperly and erred when making a ruling on an unverified, uncorroborated, imaginary, and non-existent management-conducted administrative inquiry and fact-finding investigation, but instead took the agency's unsupported and conclusory word for it to the complainant's harm and detriment. You always, at each and every phase, you always have to state that you were harmed. I've read hundreds of cases. You may hear me say it over and over again, but you have to be educated. You have to educate yourself. Even if you have an attorney, you have to be the attorney's teammate, as well as you have to perform some oversight on the attorney and help them see what they kind of missed to support your case. And you have to be able to talk to your attorney and say, hey, well, why is this not included? The only way you're going to do that is you're going to have to self-educate. I've done that self-education, and I'm not saying, hey, I haven't won anything yet. So I'm just telling you, hey, some of the components that I'm going through at this point in time. So self-education for me was reading all the cases listed on the EEOC page, and then getting a subscription to a particular tool, online tool, that has all these court cases all across America to include EEOC. And I read them, I study them, I review them, I learn the language in which complainants were dumped, and learn the language, the few cases which they won. And you get an understanding of common traps and pitfalls, potholes, and loopholes that the process takes us through. And as such, you want to find how to overcome those potholes. So taking any party's unsupported and conclusory word for it is a common no-no. So I quoted that. I didn't make that stuff up. That's just language that I pulled out from the cases that I reviewed. I go on to say the complainant is able to verify that he was pressured to participate in a management-conducted administrative management inquiry and fact-finding investigation, which refused to observe and ensure his 5 U.S.C. 2302 protected rights based on his protected activity to include EEO, and tried to illegally coerce him into signing an NDA or waiver which did not comply with 5 U.S.C. 2302 protections. But he was never granted access to the investigation. Can't verify that it was ever completed, nor can he verify that the investigation with the illegal NDA or waiver is the same one referenced in the AJ's ruling without any ID numbers, but the record fails to provide or include a copy of it, and the complainant never got his chance to perform discovery on it. Without the management-conducted administrative management inquiry and fact-finding investigation being in the record, the AJ in the March 2nd, 2022 decision failed to determine that the record had been adequately developed for summary disposition. See Petty versus Department of Defense. Now here's something else. The rules, laws, principles, requirements of summary judgment says that the AJ must determine that the record is adequately developed for summary disposition. Without having the case in there, without having this so-called administrationist fact-finding inquiry investigation as part of the record, she was negligent. She failed. She acted improperly to make sure the record was ready for summary disposition. So these are some of the nuances that we go through in trying to, at these phases. Here's a problem that we often have, especially pro se. Pro se, hey, means I don't have an attorney. But even attorneys, I found when I read those cases, they get into the trap of relitigating their complaints, right? So they know that for pro se, I complainant, I know I've been done wrong. I got a lot of facts, a lot of data, a lot of evidence that I've been done wrong. And at this phase, what I do is represent it. So what I'm saying, hey, look at this fact. Look at this page. She said, I hate you because of your EEO protected activity. And I wave that around and I swing that around and say, look, Judge, here it is. And I can be absolutely right. It actually is there. It's in the record. But I haven't completed my argument. I have to say, here it is. And the AJ improperly ruled on the evidence that was in the record pursuant to CFR 29 CFR 1614.504A. See the difference? We have to map the wrongdoing, the trespass, the foul, to the evidence, and then to the proper law. It's pretty clear. The first sentencing requirement of even asking is we have to prove that the judge acted improperly on a fact or law. Getting it now? It's making sense? If we learn to do this more effectively at the earlier stages, it makes it harder for the AJ to take certain improper liberties at the later stages. But as I think I've explained to you in one of the other prior claims, hey, they will cheat you no matter what. I've had judge throw out 8, or not throw out, just simply fail to rule, respond, comment on 8 of 18 allegations in my complaint. How do you do that? At any rate, let me keep going. Where was I? Ultimately, without evidence and proof of the purported management conducted administrative management inquiry and fact-finding investigation, then the agency failed to articulate legitimate, non-discriminatory reasons for its actions. See Texas Department of Community Affairs versus Burdine. Therefore, summary judgment should be issued for the complainant on this claim. What does that mean? It's a requirement. It's part of this law and this process, a summary judgment, that the agency must proffer or articulate a legitimate, non-discriminatory reason for its actions. It said that this so-called investigation did not warrant my request. But if there's no investigation, then they're lying or nothing substantiate their claim. So they no longer have a legitimate non-discriminatory reason, and therefore it's on me. I mean, hey, I win. All right. Finally, the March 2nd, 2022 Decision Appeal Commission neglected to cite, mention, recognize, or document the problems, errors, and inconsistencies of the illusory and unsubstantiated administrative management inquiry and fact-finding investigation, such as it not being in the record and thereby improperly failed to adhere to and hold the principles and standard of de novo when it neglected to examine the record without regard to the factual and legal determinations of the previous decision maker. That's a requirement of de novo. They didn't do it. And neglected to review the documents, statements, and testimony of record, including any timely and relevant submissions of the parties, and issue its decision based on the commission's own assessment of the record and its interpretation of law. Again, if that so-called investigation is not in there, how do they uphold that initial ruling? You hear the foul play? I want you to say, hey, Will, you're always crying foul play. You're always crying sour grapes. Somebody done you wrong. I hate that too. But what happens when it's true? There's the evidence. You just heard it. I'll continue on. But instead, the commission improperly upheld the same ruling as the prior July 29, 2020 order entering judgment with no evidence of a management-conducted administrative management inquiry and fact-finding investigation for this claim included or attached in the record. Yes, that's the third time technically I keep repeating, maybe fourth time I keep repeating. But I've seen how they will take the smallest of gaps and use that as an excuse to uphold an improper ruling or decision by a prior AJ. I continue on. C29 CFR 1614.405A stating that a decision on an appeal from the agency's final decision shall be based on the de novo standard. See also Employment Opportunity Management Directive 29 CFR 1614 EEO MD 110 at Chapter 9 as revised August 5, 2015, providing that an administrative judge's determination to issue a decision without a hearing and the decision itself will both be reviewed de novo. So at this point now, I've walked through the stages. I've repeatedly said this so-called investigation is not in the record. Then my next phase was it was improper for the judge to rule. And now I'm mapping the particular law to what I proclaim they did wrong. You have to do all these stages. Trust me. Then I go on to say, injustice will result if reconsideration is refused. I didn't make this language up. I just pulled this from another court case, EEO court case. That is, movement demonstrates that some harm, legal or at least tangible, such as him not being able to prove his claims, the agency would continue to submit false, unverified, and unsubstantiated testimony against its victims of discriminatory retaliation and hostile work environment, with assurances that the EEOC will be so overloaded that they will look the other way, and complainants will not be able to rely on the integrity and compliance of the EEO Appeals Commission. Would follow. All that would follow, right, from a denial to reconsideration. And that's in the Cobell case and the Bank Julius case. So I pulled some cases. I made that statement and I cited the court cases to say, hey, I didn't make that up. It's already established precedent. Now you're required to follow established precedent. Even if the appropriate legal standard does not indicate that consideration is warranted, the court may nevertheless elect to grant a motion for reconsideration if there are other good reasons for doing so. Again, that's part of that ruling that I said. And guess what I did? And then I messed around and repeated that whole thing. All right, so I'll take and get rid of that. It's good I had a chance to read it out loud to you, right? You know, when you read the stuff in your mind, it all can jumble. When you read it out loud, you get to hear. When you get to hear what you're thinking and saying, it also works outside of this environment. When you get to hear it, speak it out loud and hear it, then you get to deal with or confront what you're saying. The mind can trick and play games on it so fast without an audible response or input. Finally, I go on to finish out here. It says the complainant petitions the commission to reverse the summary judgment ruling and non-ruling for claim number 15. Then review it de novo, including the facts presented in this petition and his June 13th claimant's motion for summary judgment denial, later called opposition. View the evidence on the record for claim number 15, most favorable to the non-movement, and award summary judgment to the complainant with punitive and compensatory award, or remand the claim for hearing. You have to tell them what you want. Even if I would have won all that right there, they say, hey, well, the claimant failed to tell us what he wants. He don't want nothing. He just wanted to argue, prove a point. So he won. It's over. You get no reward. All right, so that's that claim. I may share one or two more, but I just want you to get the feel, the gist, the flow of how to structure your reconsideration request. Also, you should structure your appeal, if not your initial case, in the same way. But good luck. Reach out to us on Facebook. Find us on the Facebook group. Let's support each other. Let's encourage each other. Let's share notes. The worst thing for victims is that when we keep quiet in the dark. We keep quiet. We don't get to share notes. We don't get to support each other. We don't get to point out the fouls and the wrongs of the entire system as a whole. Hey, just like the Harvey Weinstein case or the Bill Cosby case, it had to start with one or two people saying, hey, that happened to me. Then a lot of people said, it also happened to me. And we got together and hopefully, piece by piece, as a federal employee, we can help our federal environment become an inclusive, righteous, just, lawful, non-discriminatory, non-retaliatory, non-harassing workplace. Lofty goals, but the law says we're going to try. All right. Thanks a lot. Make comments below. Bye-bye.